The gentleman from California, Mr. Kiley, is recognized for 5 minutes.
Good morning, Ms. Khan. A few days ago, you lost another case. This was your challenge to the Activision acquisition. The Northern District of California, in an opinion by a Biden appointee, denied your request for a preliminary injunction. After what the court called a voluminous pre- and post-hearing written submissions, the court found you are not likely to succeed on the merits. You seem to be losing quite a bit, and I don't say that to be disrespectful, but these are, after all, taxpayer funds. You're now 0 for 4 in merger trials. The average win rate for the FTC in the modern antitrust era is around 75%. So I have to ask, why are you losing so much?
Thanks for the question, Congressman. I should note, first of all, that the FTC has some of the best litigators around. And in the very trial that you mentioned, it was just phenomenal to see, and the judge herself personally commented on how the fact that the FTC, despite being totally out-resourced by some of these companies, was really able to go toe-to-toe in terms of legal talent and skill. And I'm enormously proud of our litigators.
Well, I'm not sure the taxpayers are going to take much delight in the legal talent and skill of enforcement actions that cost great taxpayer dollars and end in defeat. So the question is, why is your track record so poor when it comes to actually winning cases?
Congressman, we've had significant success in the courts. There are a whole set of matters, including our case against Martin Shkreli, where the court found resoundingly in the FTC's favor, also banned Martin Shkreli for life from the pharmaceutical industry. We also had...
Okay, so you're 0 for 4 in merger trials. And so when I was trying to figure out what's going on here, I found maybe a clue in an article from the New York Times, December 7th, 2022, which reported comments you made at a conference where you said this. You said, if there's a law violation and agencies think that current law might make it difficult to reach, there's a huge benefit to still trying. She added that any courtroom losses would signal to Congress that lawmakers need to update antitrust laws to better suit the modern economy. I'm certainly not somebody who thinks that success is marked by a 100% court record, you said. So this raises the question, Chair Khan, are you losing on purpose?
Congressman, the key clause in the quote you mentioned was, if there is a law violation. We only bring cases when the facts before us lead us to believe that there is a law violation under the existing laws. On the merger front, there are a whole set of cases where we've won, including in instances where the parties abandoned and walked away after the FTC
you're 0 for 4 in merger trials.
complaint.
So what did you mean when you said that any courtroom losses would signal to Congress that lawmakers need to update the antitrust laws? What does that mean?
So there is an institutional dialogue, right, between enforcers, between Congress, between the courts. There's a century worth of antitrust back and forth between the agencies, between Congress. This very committee in the 1950s determined that the agencies were not bringing the types of cases that Congress was worried about in terms of monopoly power.
Okay, but you're actually bringing the cases. You're losing because you don't have the authority that you want from Congress. So this is how you think you're going to persuade Congress to give you more authority, is by exceeding the authority that you now have?
Congressman, again, we only bring lawsuits where we believe there is a law violation, given the facts and the law at hand. We fight hard when we believe that there is a law violation, and unfortunately, things don't always go our way. But we, make determinations.
But are you bringing cases that you expect to lose?
Could you repeat?
Are you bringing cases that you expect to lose?
Absolutely not.
Okay, well, your track record seems to suggest otherwise. Let's look more closely at the Activision decision, though. The court first noted that in an attempt to lower your burden, you essentially made up case law. You couldn't find anything actually that's the courts have provided in terms of precedent, so you cited to your own FTC decision as precedent. But irrespective of the legal standard, the court, you probably wouldn't have won under any standard, because the court said this, that the FTC has not raised serious questions regarding whether the proposed merger is likely to substantially lessen competition, not raised serious questions. The court also rejected not only rejected your assertion of a likely anti-competitive effect, but found just the opposite, that the record evidence points to more consumer access. So why should Americans have faith in your judgment when this Biden-appointed judge says you are so far off the mark?
Congressman, this matter is still pending before the FTC in administrative adjudication, so I'm just going to be limited in what I can say about the merits. Our complaint lays out the staff's view of what this merger would result in and why that would be a law violation.
But the judge roundly rejected it and said there weren't even serious questions, and now having lost, you're spending even more taxpayer money on an appeal that you're even less likely to win because the appeals court is going to defer to the trial court's findings of fact in this very fact-intensive matter. So why are you spending even more taxpayer resources pursuing this appeal?
So I can say, again, this was a staff recommendation. I can say it a general matter. Staff always looks closely at an opinion and looks at whether there are certain errors in law that they believe are worth appealing on. Those are, in general, the types of determinations that go into whether the FTC ends up appealing.
Gentleman's time has expired. The chair now recognizes